Good morning, everyone, and welcome to our webinar for September. Thank you all for joining us today. For those who don't know me, my name is Kate Chalker and I'm an associate based out of our Sydney office. Our presenter for today will be Adrian Bailey, who is a principal of the firm, also based out of our Sydney office. And I'm sure that you're all familiar with Adrian and you've seen him present at least one of our webinars before. In today's session, Adrian will be looking at the role of the appointor, also known as the principal within a discretionary trust, and we'll be discussing the various aspects of the role, as well as considering some recent cases which have specifically looked at appointers. So before we jump into that, I'll just go through some basic housekeeping in case we have any new participants today. So if you would like to download a copy of the slides from today's webinar, you can do that by clicking on the Files tab on the right-hand side of the screen. But if you do forget, don't worry, because they will also be included in the feedback email, which will be circulated later today. If you do have any questions which come to mind throughout the course of the webinar, please feel free to send those through. You just need to click on the chat icon, again, on the right-hand side of the screen. You can enter your question in there. I'll be monitoring those and I'll either interrupt Adrian at an appropriate time during the webinar, or else we can get to them at the conclusion of the webinar. Just another thing to be mindful of is that we will be recording today's webinar, and it will be uploaded to our website and also our YouTube channel at a later date. So just keep that in mind when you are submitting your questions for today. All right, I might throw to Adrian to get started on today's topic.
Thanks, Kate. Hi, everybody, and welcome to the webinar from me. So today, obviously, considering the title of the webinar, we're going to be talking about the role of the appointer in trusts. And why we're talking about it is quite often you see that not enough thought goes into who that person should be, both when the trusts are being established and also when we're looking to change parts of the trust, such as when we're doing a succession planning or estate planning and considering all the different aspects. And also have a real good think about what powers should they have or shouldn't have, what sort of person they should be. So at the end of it, we'll be running through some cases, as Kate mentioned, just having a look at different aspects of what the courts thought about what the appointer did or didn't do. Agenda today, first off, we're going to consider whether a trust needs to have an appointer in the first place. What qualities should an appointer have or need, if we're considering the types of people that we want to appoint as appointers. What powers do they need? What happens if they die or lose capacity? What sort of mechanisms can we have for changing the appointer or the trustee? And when should an appointer remove a trustee? And also, can an appointer be personally liable for their actions in relation to the trust? Finishing off with some drafting tips, and as I said, jumping into those cases at the end. First of all, does a trust actually have to have an appointer? Well, the answer is no. The short answer is no, and certainly some trusts don't have a separate appointer role. In pretty safe ground in trust law to say that in order to have a valid trust, we need three elements of certainty. So we need certainty of the intention of the settlor, certainty of the subject matter, and certainty of the objects of the trust. Now, when the textbooks talk about objects of the trust, they're not talking about the role of the appointer. They're talking about the beneficiaries in terms of those being the objects and the ability to be able to determine who the beneficiaries are. So as we can see, in order to have a valid trust, we don't need to have an appointer. And it's not uncommon to come across trusts that don't have that. And that role, in terms of changing trustee, if that's the limit of the role, is left with the trustee. However, if we're thinking about it from the perspective of drafting deeds or having deeds to increase asset protection, whether that's asset protection against things like bankruptcy, or whether that's trying to protect as best as we can against family law claims, then we really should consider having an appointer within the deed. And then we need to start thinking about What sort of person should this appointer be, or persons? So leading into that, that brings us to what qualities should an appointer have, or do they need to have? And I often say to clients when we're talking about these sorts of matters and we're talking about who should be the successor appointer in an estate planning context, that really they should have common sense and backbone. A little bit simplistic, I know, but the sorts of qualities that we would want this person or persons to have would obviously be, first of all, common sense. They should be honest, hopefully. Open to seeking advice, and by that I mean nobody knows everything. So we should preferably have a person who is open to seeking that advice if they need to do it, and a lack of agenda. And by that I mean that they don't have their own personal interests in the case. Difficult to have that last one in a family situation where we've got a family discretionary trust. But it may not be possible to have the idea of not having an agenda, particularly where, as very likely they will, the clients will want to be in these positions themselves. So that's the sorts of things that we should be looking at in our appointer. But as I said at the beginning, in a simplistic way, someone with a bit of common sense and backbone. What powers do they need? Very often, the power that they will have, or the main power that they will have, will be the ability to remove the trustee and appoint another trustee in their stead. So often I explain to clients, if I'm picking up a trust deed, I'll want to look at who the appointer is or principal, or however they're described, and then also what powers that they do have. Is it the ability to remove the trustee? Or there are further powers, because if we're thinking about control and control of the trust, this is really where the control lies. Because if I can remove the trustee and replace them with somebody else, I in essence control the trust. So like many things in life, when we're dealing with trusts, it's important to read the deed. And no doubt you've heard me and other presenters and other people say this over and over again, always read the deed, because it's not safe to assume what the powers are or even who the appointer is. Unfortunately, it's not that uncommon to come across a deed where the person who has been appointed when the deed has been established is really not relevant or appropriate. And sometimes that comes about by accident, in that when it's generated, the wrong name's put in to the appointer role or something along those lines. There's also sometimes additional roles to the appointer, and you see this predominantly in Western Australia. I find the concept of having a further role called the guardian, in addition to the appointer, and very often that they have a requirement to consent to certain actions, whether that's by the appointer or the trustee in those deeds. Other powers that we might consider if we're drafting our deed and we're thinking about the sort of powers that we want our appointer to have, that could be the requirement to consent to trust amendments, the requirement to consent to distributions of income or capital, consent to adding or removing beneficiaries, or consent to vesting the trust. So these are all could be additional protections, if you could think of it that way, that we could build into the deed so that before the trustee exercises any of these powers, they must get the consent of the appointer. Now, although that provides protection, it also increases complexity because if we have to get the consent of the appointer, that's a further step that we have to do that may be missed in some instances. Or they may not consent. And in one of the cases that I'll discuss, where we end up is the situation where we have, in essence, an enemy party as the appointer who has to consent to distributions of income. And you can certainly be rest assured that I think it unlikely that they will consent to those. So those are the extra powers that we could consider having. Of course, there's others on top of that, but those are the main ones that we see. Generally speaking, it is often limited just the ability to remove and appoint a new trustee, but we should start thinking about these other things, particularly where we're drafting a deed with a view to estate planning or succession planning down the track. What about death or incapacity of the appointer? In terms of trust law and definitions, the power of an appointer is what is called a mere power, which means that it is often non-delegable. So that means that you can't, by your will, in many cases, and I've I'll go further in relation to this. In many cases, unless there's a provision within the deed that allows it, you can't by will delegate the power of appointer to somebody else because it's a mere power, it's non-delegable. However, many deeds will have a clause in there that outlines that the appointer can appoint a different person via will. So that issue of it being non-delegable is often dealt with within the deed. But just remember, if that power is not there, you can't do it by will. You'd have to do it by bearing the trust. If we have joint appointers, a trap for young players, as they say, the clause needs to be specific that if one passes, the other continues solely. Otherwise, the law stands, and what would happen with the survivor would not be able to act. A power that is given to somebody jointly only cannot be exercised if that person, the other person, is deceased or has lost capacity. So again, an important drafting tip, reviewing deeds, having a look at how is this worded. If the intention of the client is that the survivor of them, if there's two appointers, continues on, then we want to make sure that that's specific within the deed. We also need to consider succession. Generally speaking, it's always great to be able to set this up at the beginning when we're establishing the deed. We may not be able to, but we should at least have the discussion with the clients when we're establishing trust deeds to say, well, should we build in their succession now so that if you're not around, these people take over this role. When we're talking about that with clients, we should also consider whether that succession itself is controlled, in that can't be changed, for example, without the consent of the people who succeed. That's going to build in less flexibility to what we may want to do in the future, but it also locks in that succession, and it may be something that's appropriate where we want to make sure that a particular trust ends up under the control of a particular person at some stage. In terms of changing the appointer or trustee, clearly there could be a resignation of either. So that would be what you would consider to be a positive action or a voluntary change. We could also have it by a variation of the deed that changes the appointer position. Very often you would need to get the consent of the appointer to do that, but that could also be a mechanism for changing the trustee, changing the appointer. And then you need to think about involuntary changes such as death or incapacity. So often this can be done by will, however, it's not our preferred course of action. So if we want to have succession of the deed, succession of the role of appointer if a person dies or loses capacity, very often our recommendation is we do that by variation to the deed. If we do it by will, the risk always is that the person later changes that will. Whoever's drafting that will doesn't pick up the requirement to change the successor appointers, or they put a different thing in there. So as I said, much better if we do it by way of deed. That way we can make sure that we're locking in what we want, and there's less room in the future for errors in terms of later documents that are prepared. When should an appointer remove a trustee? Well, there's a few different areas and a few different reasons an appointer may remove a trustee. There's commercial reasons. So, for example, going from an individual to a corporate trustee or changing corporate trustees, we may want to do that. Succession planning. So as either part of retirement from a business that's being operated in a trust, for example, or an intergenerational transfer of the control of that trust. That may be a reason that the appointer changes the trustee. Asset protection reasons, perhaps we have a trust or multiple trusts where we've had the same trustee, individual or corporate. But that's not fatal in itself, but it just gets messy. So it may be that we want to change all of that so that we have separate trustees for each of the trusts. Last one would be if the trustee were to breach their duties. So there may be an issue where the trustee isn't acting in the best interests of the beneficiaries, or there may be other reasons that they're breaching their duties, and that may be a reason that the appointer should remove the trustee, really to protect the beneficiaries of the trust. And in the cases that we'll run through, most of them involve situations where the appointer removes a trustee or attempts to remove a trustee. And very often the reason for that is they think that they're breaching their duties, or they're looking to make sure that the beneficiaries are protected. The question you may get from a client is, if I take this role, could I be personally liable for my actions? As to whether you can be personally liable for something depends on the power that you're exercising, whether it's fiduciary or non-fiduciary. So if we have a fiduciary power, it's more likely that we could be liable for our actions than not. The way that the courts and judgments have viewed this, if it's a power, one of those extra powers we went through, was such as a consent to the trustee exercising a power that's non-fiduciary because they don't have an obligation, the power of removing a trustee has been found to be a fiduciary obligation. So if we exercise our power as appointer to remove a trustee, and we do it in a way that is really not in the best interests of the beneficiaries, then we could be personally liable as the appointer. So aside from that, it may be the situation where our actions are dishonest or an overreach of the powers. Again, there is the possibility that an appointer may be personally liable in those circumstances. Could I be personally liable for removing a trustee otherwise? Well, no, not if I'm not doing it for reasons that are really not in the best interest of everybody. And again, even though there was no actions in relation to personal liability, the cases that we'll run through, very often the changes are for those reasons, what you'd consider bad reasons. So yeah, it's certainly something that happens, and you've probably seen it in your practice. In terms of drafting tips for the appointments themselves and the variations, for existing trusts, we need to ensure that our variation is within the power that is allowed. So again, comes back to reading the deed, making sure that we read the deed properly. And we could also consider use of a will in terms of variations for the appointment of appointer, or appointing that successive provision. For new trusts, we may need to, it's not just the case of taking something off the shelf. I would think we need to have these discussions with our clients. We may need to consider whether we have reserve powers of the appointer, so those extra powers, consent to distributions of income, consent to adding or removing beneficiaries, whether those would be appropriate in the client's circumstances. We may consider also this separate role of this guardian in terms of these extra powers. Succession of the appointer role, as I said, we should always have the discussion with the clients if we're establishing a new trust as to whether anybody is to succeed them to that role. And we may think of the consideration, because of that obligation in terms of potentially being personally liable, and an indemnity clause for the appointer themselves. It's very rare to see, and we don't have it in our deeds, but that may be something that you may consider. If the appointer is somebody who is independent, so to speak, from the trust, so perhaps they're a trusted advisor or solicitor or accountant, we may also want to build in some powers for them to access trust documents, because in the absence of that, their ability to perform their role may be limited. So that's certainly a consideration if we're putting somebody independent to the family into that role, to give them that extra power. So jumping around. Yep.
I might just interrupt you with a few questions before you move on to the cases, if that's all right.
Yeah, of course.
All right. First one, just going back to your earlier slide about death or incapacity. Question is, what should happen if an appointer loses capacity?
So again, it will depend on the deed, but if they lose capacity, they can't exercise their power. Within the deed, there should be a clause there that says if they've lost capacity, they're no longer an appointer. And that way, hopefully, we've got a succession built in. But if you don't have capacity, you can't exercise your powers under the law. And it's not, as mentioned before, it's a non-delegable power. So it's not the case that the power of attorney could exercise on their behalf.
Next one is short and sweet. Can an appointer also be a beneficiary of a trust?
Yes, and very often are in a family situation.
All right, next one is, can a will effectively appoint a new appointer?
As long as there's a power within the trust deed that says that you can appoint a new appointer by will, then it can do.
Thank you. Next one, if you have joint appointers and one of them loses capacity, then what will happen in that situation?
As long as the deed states that where they're appointed jointly, then if one loses capacity, then the other continues on solely, then the non-loss of capacity appointer will be able to exercise the powers. Otherwise, it would then be the person or persons, if there are, who succeed them.
Thank you. And last question I have for now. Can minor children be added as successor appointers in the trust? And what will happen if their parents pass away before the children turn 18?
Yeah, it's a good question. And technically they can be appointed to that role. However, they can't legally act on those powers until they reach the age of 18. In fact, what would happen would be, in essence, hopefully you don't have the situation, but if you did have the situation where they passed away and under the age of 18, you would need to really, to be certain of it, go to the court to have somebody appointed in the interim. Alternatively, you could look at varying the deed at that stage to appoint somebody in the interim. But if you're doing that again, I would only make that until they reach the age of 18. So you're not interfering with the original format of the deed.
Thanks, Adrian. That's all I have for now.
Thanks, Kate. So the four cases that we're going to run through, Kadachi and Kadachi, Owies and Owies, Edwards and another, and Sehan and Sehan, which is a case very close to Kate's heart for reasons that I'll get into. But the first one is a Western Australian case, Kadachi, and hello to any people from Western Australia joining us. Kadachi and Kadachi, which was a pretty hard-fought battle involving the widow of Mark Kadachi, a lady by the name of May, and his wider family, principally being his brother Philip or Filippo. So in terms of what happened in this case, as I said, it's a very hard-fought battle, obviously very personal. It was a 30-day trial, which is a long trial, and the judgment, of course, is fairly lengthy because of that and all of the issues that arose. So Mark was part of second generation of a successful family group, and he met his wife relatively shortly before his death. I say relatively, it was about 4 years before his death. And as sometimes happens, she was a bit younger than Mark, not to say that there's anything wrong with that. But they had met about 4 years prior to his death. Unfortunately, he became ill with an aggressive form of cancer not long after they met. And as I said, died apparently 4 years after they met. They had been married in the meantime. In terms of the entities involved in this dispute, they principally revolve around the trusts, of which Mark had previously controlled, and then also his estate. There were two matters running at the same time. So there was what was known as the Washburn Trust, which Mark was the sole trustee, appointer and guardian. Power City, which was a corporate beneficiary. A testamentary trust, which Mark had not received, but had been generated by Mark's mother when she passed away, the trustee of which was the company called OnGold, and Duport, another company, of which Mark and Philip used for property development. It's a little unclear in the judgment, but the overall pool of wealth amongst these entities and Mark's estate is around the 50 million mark. So, of course, both sides disagreed over how much was actually there, but safe to say it's probably around that mark. So, following their marriage, Mark executed a variation to the Washburn Trust, appointing May as a beneficiary. And then he did some other estate planning documents varying the Washburn Trust to appoint Philip as guardian and appointer, followed by Mark and then May. He created a new will at that time, or drafted a new will, creating a testamentary trust for May, of which Philip was the trustee. So we can see that there's an intention there to benefit May, but Philip's really in control in the box seat. As I mentioned, he had a fairly lengthy illness over about 2 years, but not long prior to his death, he reviewed his estate plan, and in a letter of wishes stated that he wanted all income and capital of the trust after dealing with taxes to be distributed for the benefit of May. Following his death, things unravelled fairly quickly, and we all know what personalities are like, but the key to the unravelling seems to be the revelation that May has a new partner, being the real estate agent that sold her house. So things start to unravel between May and the family. So following his death, Philip executed 2 deeds of variation of the Washburn Trust, the first appointing a company called Washburn as trustee, and the second varying the terms of the trust to appoint himself as appointer and guardian. In May 16, there was a coffee meeting between May and Philip. May 2016, May and Philip is alleged to, and the court found that these words were said words similar to, "I'll never distribute anything to you from the trust or the company. I'm going to give it all to a foundation established for research into the cancer that killed Mark." Now, what they used to do in terms of funding living expenses, and you've no doubt seen this with clients a bit, is that they would take all the money that they were using in their living expenses out of Power City, which was the corporate beneficiary, and then at the end of the year, they would declare a dividend, offset the loan. So that was pretty common practice. And in the last few years of his death, before his death, I should say, they were spending a lot of money because not just medical treatment, but when he was well enough, they were living life to the best that they could. So lots of money was getting spent, and there was a fairly large debt owed to Power City by Mark at the date of his death. Now, that following his death, the decision was made not to declare the dividend. So we had a debt from the companies to Mark. So Mark's estate was technically insolvent because the amount of the debt was more than the assets within the personal estate. So Philip placed Mark's deceased estate into bankruptcy. It's getting pretty nasty, obviously. And then shortly after that, Philip and his sister Angela prepared documents to replace Ongold, which was the trustee of the Testamentary Trust, with another company called Rectangular. So May subsequently commenced proceedings, one in relation to the trusts and the bankruptcy of the estate, and one in relation to a family provision application under the will. Judge is fairly scathing of what he called the evidence of Philip's side in terms of their behaviour in this matter. And what the judge subsequently found was that the trustee of the Washburn Trust and the Testamentary Trust should be removed, and May appointed as trustee in their stead. And this was principally on the reason that the court was satisfied that Philip had made that statement, that he'd said, "We will never distribute anything to you," and that being the appointer and having the power of appointment and replacing the trustees, he was not doing that for a proper purpose. For the Washburn Trust itself, unfortunately, Philip remained as guardian of the trust, and under the terms of that deed, then he had to consent to distributions of income. Clearly, he's never going to do that, which limits May, and that was identified by May's lawyers. With that, they attempted to have him replaced as a receiver of the trust, with a receiver for that power. But as mentioned before, the power is non-delegable. It's a mere power. The court found there's no ability to appoint a receiver in the place. So we have this situation now where with the Washburn Trust, May is the trustee or controller of the company that's trustee, but Philip's still guardian and has to consent to distributions of income. Philip was removed as executor. The net estate was awarded to May. So shows that in terms of what we do as the appointer and what Philip had done and his sister here, we need to make sure that we're doing it for the right reason, so to speak. Clearly they weren't in this situation as things had gone fairly toxic, and that was found to be by the court. Just a bit of further colour or further background. May then went on to sue the advisors who prepared all the documents. I don't know the resolution of that. And now she's again back suing the family for an earlier restructure of a business that she says deprived the trusts of some assets. So she's becoming quite the model litigant, I would say. If you're interested, she had a litigation funding agreement for the first matter, Kadachi and Kadachi, and the fees paid to the litigation funder were $10 million. under the terms of the agreement. So clearly lucrative business if you're a litigation funder, but obviously the risk that comes with that you don't win. Next case to talk about owies and owies, and it's not so much about the role of the appointer, but what we're looking about here is the trustee and what the trustee does or doesn't do. So we've got John and Eva, parents. They established a discretionary trust in 1970. Named as primary beneficiaries of the trust were their children, and they were listed as additional classes of general beneficiaries. So they had 3 children, Michael, Paul and Deborah. Paul and Deborah became estranged from their parents, with Paul not receiving anything from the trust and Deborah receiving an apartment as a capital distribution in 1 year. In the years in dispute, the trust resolved to distribute the income 40 to John, 40 to Michael and 20% to Eva, except for 1 year in which 100% was distributed to John. So as beneficiaries, Paul and Deborah sought orders that the trustee be removed, as they stated the trustee had breached their fiduciary duty in not giving real and genuine consideration in their circumstance. So the court did agree with them and said that the trustee hadn't made inquiries of their circumstances, hadn't given real consideration to them, and the distributions were voidable and the trustee should be removed. Owies and owies, if you start thinking about it, it's not really, the proposition that the trustee has to consider beneficiaries, but it's a bit peculiar circumstances in this where the children were the primary beneficiaries. I wouldn't be too concerned about it, thinking, well, I can't just distribute as I normally distribute, but you do have to be able to show that you had considered the other beneficiaries when you made the distributions. Edwards and Brown, which is a South Australian case, and this again is a dispute about the appointment of a trustee, or attempted appointment anyway. So the family dispute involved Peter and Pamela and their son John. So at some stage, by the looks of it, as part of some succession planning, what they had done is they had established a trust called the Brome Farm Trust, of which the son John was the trustee, and all 3 were default beneficiaries. Peter and Pamela, the parents, had the power to replace the trustee, so they were the appointers. Once the trust had been established, they transferred the family farm, which had been in Peter and Pamela's name, to the farm trust. So as I said, looks to be some family succession planning there. Peter and Pam want to transfer the farm to their son so he can keep farming it. They've transferred it to him in a trust. But clearly they wanted to make sure that they weren't kicked off the property or denied access to things by retaining that role of the appointer within the trustee. So John's the trustee, but they're still the appointers. 2 years after they established this, Pamela passes away, and then shortly after that, Peter and John had a falling out in September 2020. And then that led to the following occurrences, and I'll read through the dates because they are important. So on the 2nd of October, John went and saw a solicitor and gave him instructions to prepare documents to distribute all of the capital of the trust to himself, so all of the farm to himself, and signed the client authority on that day. And the solicitor went ahead and lodged a caveat over the land. On the 9th of October, even though they've had a falling out, clearly word has gotten around this town in South Australia. Peter's gone along to see a separate solicitor, so Dad, and he's instructed a solicitor to remove John as trustee. On the 15th of October, those documents were prepared and executed by John, and he appointed himself and his accountant, Mr. Edwards, as trustee. This was posted to John on the 16th of October, who received it on the 21st of October. Also on the 16th of October, again, what's going on in this small town? They must be watching each other out the windows. John executed a deed poll transferring the property to himself, and for whatever reason decided to backdate it to the 2nd of October, so the date that he'd originally seen the solicitor. 30th of October, transfer was lodged, and the property was transferred from the trustee, being from John, to himself. On the 9th of November, Peter and the accountant, Mr. Edwards, varied the trust to appoint Mr. Edwards as appointer from the death of Peter. That was important Peter had a terminal illness and died before the court matter was finalised. So the question then is, did John transfer the property from the trust on the 2nd of October? If he didn't, then he was removed as trustee on the 15th when the deed removing him as trustee was executed. Or did he have to be served notice of the deed, which would have made it on the 20th when he received it in the mail? If it was the 20th, then does the fact that he signed the transfer documents on the 16th mean the property is no longer in the mail? Sorry, the property is no longer in the trust when he receives notification that he's been removed as trustee. What the court found in this matter was that him signing a client authority form on the 2nd was not the same as signing the document to transfer the property to himself, or the resolution, and that the document signed on the 15th by his dad removed him as the trustee, and it didn't matter that he didn't get notice of that until the 20th. It was effective from that date. A case I'll talk about next took the opposite view, but that's what happened in this judgment. They said he was removed as of the 15th. So then when he signed the deed poll and the transfer later on, he wasn't actually the trustee, so that was invalid. The property was then transferred back to the trustee of the trust by the court, which was then the accountant, Mr. Edwards, as Peter had passed away. So again, we see here that what John tried to do, he didn't have the power to do it at that time because he'd already been removed, and that removal was found valid. If you think about it now, it's a strange situation to be in that the accountant is now the trustee of the trust that holds the farm. Peter and Pam are both deceased. I don't know whether there are other brothers and sisters, but what's the accountant going to do moving forward if John's the only child? Really doesn't solve anything in the long run. But I guess as the trustee, or when he was found to be the valid trustee, Mr. Edwards had to act in the best interest of all the beneficiaries, not just John. And moving on to our last case that we're going to run through, and as I said, it's a case that's very dear to Kate Chalker's heart because we acted for the defendant in this matter, and she had lots of fun acting for this family over a number of years. So anything I do say will be stuff that's on the record, so don't worry about the fact that we acted. But we had in this situation, it was again a family dispute amongst a Turkish family. So we had Dad, Mehmet, and he had two sons, Kadir, who's also known as Sam, and Memdu, and we acted for Sam. Sometime, very early on, Mehmet established a trust for the benefit of the family. He was the trustee of the trust, and Kadir was what was called the nominator under the trust deed. So the nominator had the power to remove and appoint the trustees. So akin to an appointor role, just called something differently. There was continual falling out within the family. Sam would come into favour, Sam would be out of favour. Memdu would be out of favour, back in favour. And eventually, what occurred, again, we've got a series of deeds that were signed. And the real crux of the case when it came to the hearing was which deeds were effective, because again, when we go through the timing of them, different things happened at different days, and it depended whether a person was the trustee at that time or not the trustee. So at one stage, Memdu was clearly out of favour. In 2008, Mehmet prepared a deed varying the trust to remove him as a beneficiary, added other family members as beneficiaries, and added an alternative trustee, which was not relevant to the proceedings in this case. Kadir consented to the variation under the document, or not strictly necessary under the trust deed, so that happened in 2008. Fast forward to 2018, Memdu's back in favour. So in February or March 2018, a deed of amendment was again prepared by Mehmet, which added Memdu and his children back as beneficiaries of the trust. So it's welcome back, Memdu, you're back in the family fold. Replaced Kadir as nominator and replaced him with Memdu. So Kadir, you're out as nominator, Memdu, you're in. Kadir didn't sign that deed. And further on, other parts of the deed was to remove Mehmet as trustee and replace him with Sam and Memdu. So the brothers become trustees together. So he didn't consent to that. He didn't sign that document. In May 2018, Kadir obviously thinks I'm going to get dudded here. So he goes to see some lawyers, not us, and signs a deed replacing Mehmet as trustee and replacing him with a company called Seahan Property, of which Kadir's brother-in-law initially was the sole shareholder and director. Further deed was signed on 31 May 18 between Kadir and Seahan Property, which limited the powers of the trustee. Memdu gets wind of this. He was actually notified by the bank that there had been a change of trustee prepared. So in June 2018, Memdu signs a deed amending the trust to appoint himself and Memdu as additional nominators and requiring any decision to be by way of majority. So in terms of the eventual outcome, what the case revolved around was the deed that Kadir signed, or Sam signed, on the 31st of May effective, in that it replaced Mehmet, his dad, as trustee and replaced it with Seahan Property. And there were two underlying issues with that, with whether that was effective or not. Because if it was effective, when Memdu signs the document in June appointing additional nominators and requiring decisions to be by way of a majority, he couldn't do it because he wasn't the trustee. So, important question. 31st of May, is this document effective to replace Mehmet with Seahan Property? As I said, two underlying issues in relation to that deed. One was evidence that was given and provided that there had been some discussion about the deed, the change of trustee would be held in escrow until the bank gave its consent to the change of trustee, because the bank had, $70 odd million worth of property in this trust. The bank had a fairly large mortgage over it. So there's interchange of correspondence and discussion to say that the change of trustee wouldn't be effective until the bank consented. So the lawyers prepared the documents, sent them off to the bank and said, do you consent to this? And the second thing was whether the old trustee had to be given notice. Now, there was nothing in the deed that required the old trustee to be given notice, Dad, Mehmet. Sometimes you see that in deeds, but there wasn't anything in this. Court found against Sam, our client, in that they found that there was the intention that the change of trustee was not to be effective until the bank gave its consent, and it was in effect in escrow until that time. By that time, the consent came around. Memdu had already prepared his document, appointing himself and Memdu as nominators and requiring anything to be by majority. So Sam couldn't. The deed wasn't effective to replace Mehmet as trustee at that time. And the second part was this concept of notice again. And in this case, the court found that Mehmet needed to be given notice that he'd been replaced as trustee. So opposite to the earlier case that we discussed in South Australia. So at the end of it, Sam was found not to have validly replaced Mehmet as trustee, and the later deed that Memdu signed appointing himself and Memdu as additional nominators, requiring any decision to be by way of majority, was found to be valid. So Mehmet continues on as trustee in essence. I'll open up to any questions, Kate.
You're actually off the hook at the moment. I don't have any further questions for you.
Oh, let's pull it up now. Stop the webinar. Safe to say one of your favourite matters you've worked on, Seahan and Seahan, Kate?
It was memorable. It was a good process to be a part of.
Yeah. Like many family situations, there's no real winners at the end of the day, you'd have to say. And that realistically, they all wanted the same thing. They wanted to share the assets equally amongst the brothers, but they just couldn't trust each other.
Yeah. All right. So do you want me to wrap things up, Adrian?
Yeah, if you want to just run through other things, and then if questions come in, they come in.
Right, no problem. Thank you, everyone, again for attending today's webinar and for your participation. As I mentioned at the start, there will be a feedback email circulated later today. It is fairly brief, and I think now we've introduced some lovely smiley faces, so you can just click on the smiley face for how satisfied or unsatisfied you were with today's presentation. So if you could just take that short time to complete the survey, it would be appreciated. And there will be another webinar in October. The topic hasn't yet been decided, so if there is something that you are interested in hearing about, please do include that in the feedback email. We're always interested to hear what you might be keen to hear about in our next topic. Other than that, if you could keep your eyes peeled for that email about the October webinar, we hope to see you there. I think I have had a few questions come in. Let me just go through them now. Question from Shane, is the bank's approval always required for a change of trustee?
If there's borrowings, very likely there's going to be a covenant that the trustee is not changed without the bank's consent. So it's very likely they'll need to give approval eventually. It's usually a covenant that's not a fatal breach in that you can always get consent afterwards, but it's best practice to let them know about it if there's borrowings on the trust.
Yeah. Next question from Mark. Is it still applicable or relevant that having two appointers can help with asset protection for the trust assets?
It is, and particularly in asset protection in the perspective of family law, then we have a better argument that it's not just Kate, for example, if it's Kate plus Liam as the appointers. So that's certainly something that you should be looking at.
Next question from Roy. Do you have any recommendations on an ideal appointer?
Not so much recommendations on an ideal, but as I said earlier, somebody with common sense and backbone, really.
Okay, I think there's just one more. Considering the issues relating to primary or named beneficiaries, would you suggest setting up a discretionary trust with only one named beneficiary, with the rest of the family being beneficiaries through the definitions only?
Certainly an approach that you can take. I guess the issue with it is then what happens if it's that beneficiary. But very often you would set it up so that the key person or persons are the named beneficiaries, and then you leverage off that in terms of the description of the other beneficiaries.
And just one more that's come through. Is it necessary to have a named beneficiary?
Yeah, if we don't have beneficiaries, we don't have trust, because we need certainty of the objects.
Yeah. All right, that's all I've got for the time being, Adrian. So we might wrap things up. If you do have any more questions that come to mind, feel free to contact Adrian or I. But otherwise, we'll let you off with a little early mark, let you get back to your Thursday. Thanks everyone for joining, and we hope to see you next time.
Thanks everybody.